event, I'm going to review a few things just to make sure that there's an understanding of public comment. It's been said in the past by previous chairs, I think it's said every year, that our meetings are not public meetings. By law, they are business meetings being held in the public, in the sunshine. It was even alluded to that we should hold our business portion of the meeting another time so that we get right to public comment. That's not the purpose of the meeting. However, we're glad to hear input from our citizens on items of public concern relative to this organization, and of course we will always continue to do that. Up until about 2014, there was no law requiring that public comment even be part of our business meeting. We have always done that, and I believe all the other government agencies in the county have done that. I'm assuming that hasn't always been the case, although with that privilege of speaking come rules, parameters for speaking. In 2014, the legislature, because apparently something happened somewhere, made a law that says that we must listen to speakers who have want to speak to an agenda item, which therefore means that that person needs to speak before something that we're going to vote on at that particular meeting, which is why sometimes we may rearrange speakers if we have an excessive number of speakers so that we follow the law and allow that to happen. Even though that new law is in place, the rules of speaking still apply to this meeting. Our attorney, Harold Weisslein, has done a bunch of research. As we know, this is a misunderstood portion of the meeting where people are not exactly sure what the parameters are. This has been challenged in courts apparently numerous times, and Mr. Weisslein has given me some case law to recite, so maybe there's some more clarity on public comment. These are from case law. The public comment portion of a school board meeting is a limited public forum for a purpose of the First Amendment to the United States Constitution. As such, regulation of speech during public comment must be reasonable and viewpoint neutral, but that is all they need to be. There is significant governmental interest in conducting orderly, efficient meetings of public bodies, and the presiding officer has the authority and discretion to regulate speech that is irrelevant, repetitious, or disrupts, disturbs, or otherwise impedes the orderly conduct of the meeting, so long as the speaker is not stopped from speaking because the presiding officer disagrees with the viewpoint of the speaker. Finally, the federal courts have consistently held that the prohibition of profane, abusive, or slanderous speech during the public comment portions of the meeting are required, and requiring speakers to abide by the rules governing the public comment period do not violate free speech protections of the First Amendment, as they are reasonable and viewpoint neutral. As I had said before, I believe that we're all advocates for children here, which is why we're all here, and therefore I believe we should all be good role models, because frequently there are children that are in the audience watching us, or may even be watching the videos that we post online. As I understand that Boy Scouts even have to watch a public meeting for, I believe it's a civics badge or something of that nature, citizens badge, and so they frequently watch school board meetings. Mr. Weisslein, you commented to me that there was a ruling relevant to, I believe it was prayer, where the courts had ruled we're an extension of the school for that aspect. Could you explain a little bit about that?
Yes, sir. Well, the courts have held that prayer preceding a school board meeting is unconstitutional because it's commonly known that children are frequently in attendance at school board meetings, and they're young and they're impressionable, and the courts are concerned about the children might consider the prayer or the speaking or the type of prayer for the organization to be endorsed by the governmental body. So therefore, prayer to open a school board meeting is not permitted under the Constitution, because children are frequently going to be exposed to the meeting.
Thank you. And we all agree with that, and I think we all acknowledge that is a concern at our meetings, and so we do believe in that. While some may disagree with where I draw the line on speaking, most agreed. Not everyone will ever agree with that decision. It doesn't matter where we draw the line there will be people that disagree. So I ask that everybody be respectful of the rules with no profane, abusive, or slanderous speech. And please don't do anything to disrupt the meeting, and there will be no reason to cut off anybody at the microphone. I will, as I have before, give a warning, and whether you disagree or not, please heed the warning, and I hope that you continue at that point respectfully to the attendees of the entire meeting and to the process of the meeting. So with that, we'll go ahead and call on our speakers.
Good morning. As you may know, my name is Dean Paterakis, and I'm a candidate for School Board District 4. What concerns me about the board and its attempts to silence citizens is especially after the recent arrest of our Brevard County principal, which validates my concerns. According to the affidavit, there were 14 movies which depicted young boys between the ages of approximately 8 and 12 years of age engaging in sexual activities and each other and adult males. There are more details, but are too graphic to share today. Using the medical words for male genitalia that we use in 5th and 6th grade sex education classroom is not a reason to violate my free speech because you find those words offensive. And slander is only slander if my statement is false and damaging. So, Amy Nacy all of a sudden wants to vet principal candidates as if she only just now found out that there are pedophiles in our schools. This behavior of the board and its old and worn out response that we made mistakes, but we'll do better, and now on we are going where it's getting old with the citizens of the Brevard, and I believe they are not going to fall for it any longer. What concerns me is that the former school board candidate Denise Coyle exposed these abuse issues and other grave issues 3 years ago, and although we were promised things will be fixed, they haven't. Employees with criminal records who are prohibited by law to work in Brevard schools were working in our schools, and no one was held accountable for hiring them. There is another teacher who Denise Coyle exposed who was bullying and sexually harassing students. And when an 18-year employee, Louis Rapallo, came to her and a student's aide and asked to have a meeting with the senior staff, he was fired for bringing the subject up. This teacher, James Wilkins, is now moved to another school. I understand he continues to work now with elementary students instead of high schoolers, and I asked Brevard County why. Just like Principal Ricky Shepard, who I believe had enough in his personal file to exclude him from working with young children, is moved to another school and is promoted, and I asked why. But back to the reason I was arrested the last time I spoke. I came to ask why a teacher who even by the superintendent's letter of reprimand writes, due to the egregious and repetitious nature of this issue, we are invoking Article 18, Section No. What does repetitious mean? What has he done before? How come we don't know this? I encourage you, every student, to Google Noisy Room and Brevard schools and read all of the cases that they have come up with. Let's not just vet principals, let's vet all employees of Brevard schools. And let's start with the employees that keep getting moved from one school to the next. I think that is a good start.
Thank you, Mr. Paterakis. Your time is up.
We need to put children first. Thank you.
And thank you. That was probably one of your best speeches. Thank you. I wanted to also make a comment about something that was said, and has been said repetitively, about possibly conflict between myself and that previous speaker from last meeting. Just so you all know, that speaker was 27th on the list, and I elevated him to 3rd on the list. If there was a concern or I wanted to use a conflict, he would remain 27th on the list. So I believe in taking the high road, and professionalism outweighs personal opinion.